Illinois versus Perkins. What happened in this case was the police suspected the defendant was involved in murder. At this time, the defendant was serving time in jail. So the police sent an undercover police officer to a jail cell and then pretended to be a fellow cellmate. And then this undercover police officer talked to the defendant, and then the defendant actually told the undercover police officer a murder he had committed. So the issue, and then of course the defendant was brought to trial for murder, and then the defendant claimed the police could not use his statement in his trial because the defendant claimed the undercover police officer did not issue the Miranda warning before interrogation. So the issue here we have was whether an undercover police officer must issue a Miranda warning to a suspect before the police officer could get his statement. The ruling of the court was there was no need to issue the Miranda warning in this case. And then we know we have two conditions required for the police issuing the Miranda warning. One is the person is in police custody. Another one is there is a police interrogation. So in this case, the police officer investigated whether the defendant was involved in murder. So this conversation the police officer had with the defendant certainly could be considered a form of interrogation, because the police officer did ask the defendant whether he involved in the murder or not. But the court said, but in this case, why there was no Miranda warning was needed, because the court said the suspect, the defendant in this case, was not in custody. We must understand this. When the police officer had this conversation with the defendant was in jail, serving time. So why did the court say the defendant was not in custody? The meaning is the defendant was not in custody for the purpose of the Miranda warning. We understand the court created this Miranda procedural protection because of this coercive atmosphere at this police custodial interrogation. When the suspect is brought into custody and then surrounded by police officers, and then the police officer would interrogate the person. The court said in that circumstances, we would have this coercive atmosphere at this interrogation. So to overcome this coercive atmosphere at this custodial interrogation, the court said before interrogation, the police must issue the Miranda warning. But we need to consider whether in this case, when the defendant talked to the police officer, whether we had that coercive atmosphere or not. Apparently not, because in this case, when the defendant talked to the police officer, he was actually bragging about the murder he committed. He did not know. He was talking to a police officer. So in that sense, there could not be this coercive atmosphere present. So that's why the court said there was what happened in this case when this undercover police officer had this conversation with the defendant, there was no coercive atmosphere, so the defendant should not be considered as in police custody. So the ruling of the court in the case was there was no in custody for the purpose of the Miranda warning. So that's why this undercover when undercover police officer interrogates suspect, there is no need for the police to issue the Miranda warning. This Moran versus Burbine, the issue was the defendant was arrested was arrested, and then the police was investigating the defendant for this crime, and then the defendant's sister retained a lawyer for him. And then the police actually was suspected the defendant was involved in the murder, and then but the defendant, and then the police did issue the Miranda warning to the suspect, and then the suspect, the defendant indicated he would want to waive his right, and he wanted to talk to the police. But of course, the defendant did not know his sister actually retained a lawyer for him, and the police, of course, did not inform the defendant that his sister actually retained a lawyer for him. And then the defendant actually just waived his Miranda rights, and then the defendant just confessed to his crime. So the issue here in the case was whether this police failure to inform the defendant that his sister retained a lawyer for him, whether this police action was in violation of the defendant's Fifth Amendment rights or not. The ruling of the court was it was not in violation of the defendant's right, because the court said whether the defendant wants to waive, whether the defendant wanted to waive his right or wanted to exercise his right, he must determine that by himself. Others, what other people did was irrelevant. So meaning is the police failure to pass on the information that his sister retained a lawyer for him, the court said that was irrelevant to the case. The court said by law for a suspect to waive his right, and then the decision, of course, must be voluntarily made. And then the legal requirement for waiving one's right is the decision to waive the right is made voluntarily, knowingly, and intelligently. But this means so long as this decision was made voluntarily, knowingly, and intelligently by the suspect himself. And then this legal requirement is satisfied. Other people's action, family members and friends, and if they retain a lawyer for the suspect, the court said that really doesn't matter. That is irrelevant, because this right is the right of the suspects. So the suspects must determine for himself whether he wants to exercise or waive his right. So long as his waiver is voluntary and knowingly made and intelligently made, and then this waiver should be considered valid. In the last case, that in this Schumberg versus California, and then what happened in the case was the defendant was involved in this drunk driving, and then the defendant was in hospital because he was injured, and then the police actually asked doctor in the hospital to draw his blood for analysis. And of course, the defendant was objecting to that, but the police actually forcefully just drew blood from him. And then the issue in the case was whether this police action was in violation of the defendant's Fifth Amendment right against self-incrimination. Of course, also whether there was a violation of the Fourth Amendment right against unreasonable searches and seizures. As for this Fifth Amendment protection, it is very important for us to understand. The ruling of the court was there was no violation of Fifth Amendment protection against self-incrimination. The reason was this. The court said under the Fifth Amendment, what is protected is simply the police could not force the suspect to make a statement. Meaning is this evidence must be of evidence of testimonial or communicative in nature. So that means that has to be what a suspect stated. Meaning is, under this Fifth Amendment protection against self-incrimination, the defendant cannot be compelled to testify against himself in court. And also the police cannot compel a suspect to make a confession. And then in either case, we know this is there must be testimonial, must be something the defendant or the suspect stated. But the police cannot compel a suspect to make a statement that is true. However, the police may force a suspect to put on a glove, to put on a jacket, or to forcefully draw blood from the defendant, or maybe take a hair sample from the suspect. All this would not be in violation of the Fourth Amendment. We need to understand in these circumstances, if a police would force the defendant to put on a glove, maybe the glove was a bloody glove found at this scene of the murder, and then we know if indeed the glove turned out to be fit, and then this would be evidence, would be incriminating evidence. But nonetheless, this would not be in violation of the Fourth Amendment because this evidence is not what the defendant, what this suspect stated. We know Fourth Amendment, this Fifth Amendment protection is limited to the to the situation that the police cannot compel the defendant or the suspect to make a statement. But putting on a glove and putting on a jacket, these are not statements made by the suspect. So the suspect is not protected by this Fifth Amendment protection against self-incrimination. So this is a very important point. We need to understand what is protected under the Fifth Amendment. In the case, of course, we also have this Fourth Amendment issue, that is protection against unreasonable searches and seizures. Drawing blood, we must make it clear. It is a form of, it is a search. Because if a police just search your pocket, of course we understand that it is a search, but if a police would forcefully draw blood from someone, that is a search of the person's blood, that is a search of a person's body. That is also a form of search. But in this case, the court said there was no Fourth Amendment violation because the police had probable cause to believe the defendant was involved in drunk driving and caused this accident. And then the police, based on that, the police could conduct a search. But of course, we know we also need this. We also have this warrant requirement. Police normally should have this warrant before they can conduct a search. In this drawing blood situation, in general, police should have obtained a warrant before they do this. But in this case, the court said there was an accident circumstance. Because if the police would not draw the blood in a timely fashion, and then this blood alcohol level would diminish, and then the evidence would be lost. So because of this emergency situation, because of these accident circumstances, the court said the police were justified in conducting this search without a warrant. So in the case, the ruling of the court was there was no violation of the defendant's constitutional right. There was no violation of the Fifth Amendment, and also there was no violation of the Fourth Amendment.